We're just giving it a couple of minutes, folks, so bear with us while a number of other attendees are joining, and we'll be with you shortly. Good afternoon to you all. At some point there will be 240 of you listening to us this afternoon, so welcome to the first in this series of the West Midlands Safeguarding Lead seminars. This session is on self-neglect and applying the Mental Capacity Act. I'm led to believe that we might be having a national Microsoft 365 outage issue. Please don't ask me to define that for you. I have no clue. I'm just told to say it. But if we do go down, we're taking you all with us, and we'll just cancel and rearrange another date. So look out for messages from us if we get any significant problems. We are recording the session, so it's going to be available for those who haven't been able to make it today, and we'll make it available through Shropshire and Telford and Wrekin Council Safeguarding Partnership websites, and we'll also host it on the West Mids website as well, I assume. Okay, so I'll just talk you through the structure so you know what's happening. So the first speaker is Victoria Worthington from Telford and Wrekin Council, and her section of the presentation is on the learning from Michael Preston Shute et al.'s summary of safeguarding adult reviews in London that were largely about self-neglect. It's really important that we kind of take the learning from all of these, and I'm sure this afternoon is going to be a really interesting session for you with what we've got planned. Then you'll be coming back to me, and I want to talk to you about Mrs. M, who is a woman that we went to the Court of Protection about, and you'll hear more about her later on. And then you'll hear from Lorraine Curry, a name I'm sure you'll be familiar with. She's nationally renowned for her knowledge around the Mental Capacity Act. We're very lucky that she works for Shropshire Council, so I don't want anybody poaching her. But she will be talking to us particularly about how we apply the Mental Capacity Act in relation to people who self-neglect. The other thing to warn you about is there's going to be a slight delay. So there's a 20-second delay from me speaking and you hearing me. And I assume that means there'll be a little delay as well in us getting the questions from you. Now, after we've had the three presentations, there's going to be a Q&A panel. So that will involve all of the speakers, but also we're joined by Alistair Potter, who's a safeguarding practitioner who worked with Mrs. M, and Paul Kelly from our housing team, who also worked with Mrs. M when we were first engaging with her. So if you've got any questions for those practitioners directly, address your questions in the chat and we'll get to them in the question and answer session. So I'm sure you'll be aware this is a presentation. It's not an interactive discussion with you until we get to the Q&A session. But we have Emma Hoarding with us, who's going to moderate our questions. She's going to select the questions and read them out when we get to the Q&A panel session. And then we'll take it from there. And then last thing from me is look out for Lorraine's face change as the builders either walk past her in the background or start knocking something down in her house. Because if you do see a bit of a quirky reaction from Lorraine, that's the reason, so don't panic too much. Okay, I'm going to hand you over now to Victoria, and she'll start us off with the first section of the presentation.
Okay, thanks, Sarah. Good afternoon, everyone. Vicky Worthington, Service Delivery Manager for Adult Safeguarding Community Social Work at Telford Council. One of the key challenges in adult safeguarding is ensuring the well-being of adults where risk arises from self-neglect rather than from a third party, particularly where the person refuses to engage with support. Research has identified that social care and health professionals, range of professionals, often find self-neglect practice to be enormously challenging, and it can be fraught with ethical and also legal dilemmas, particularly when adults are judged to have mental capacity to refuse support. Practitioners report feeling anxious, exposed, uncertain how to balance duty of care with a person's right to a private life. Organisational systems may also not really clearly locate responsibility for complex cases that require flexible multi-professional interventions or facilitate effective practice, which really does require the ability to build relationships over time with people, balance concerned curiosity with respect and persistence, and to be able to evaluate possible legal options. It's therefore critical that we maximise sources for learning for practitioners, but also for organisations. As I've said, self-neglect is really complex and diverse, and recent thematic reviews have found that self-neglect has been centrally involved in a significant proportion of safeguarding adult reviews. Analysis of safeguarding adult reviews that was undertaken recently by Bray et al. Involving self-neglect really identify the complexities, the dilemmas and the challenges for practice for agencies and multi-agency partnerships, and has highlighted the components of effective adult safeguarding in this field of practice. So as part of today's seminar, I'm just going to set the scene because it's such a complex area. You know, we could spend the whole 2 hours exploring the causes of self-neglect and the approaches to practice. But I'm just going to briefly cover some of the approaches to self-neglect and key findings and recommendations from the analysis of safeguarding adult reviews. So what is self-neglect? So the Care Act included self-neglect as a category of harm and made it a responsibility of safeguarding adult boards to ensure that they cooperate with all agencies in establishing systems and processes to work with people who self-neglect and to minimise risk of harm. And whilst there isn't one universally accepted definition of self-neglect, the Care Act statutory guidance defines self-neglect as a wide range of behaviour, neglecting to care for one's personal hygiene, health or surroundings, and includes such behaviour as hoarding. The Care Act places specific duties on local authorities in relation to self-neglect in terms of assessment and inquiry. Local authorities must make or cause to be made whatever inquiries it thinks necessary to enable it to decide what action should be taken in an adult's case when local authorities got reasonable cause to suspect that an adult in its area has needs for care and support, is experiencing or at risk of self-neglect, and as a result of those needs is unable to protect him or herself against self-neglect or the risk of it. Mental capacity is a key determinant of the ways in which professionals understand self-neglect and how they respond in practice. The autonomy of an adult with mental capacity is respected. Efforts should be directed to building, maintaining supportive relationships through which services can be negotiated. And when a person has been assessed not to have capacity to understand and make specific decisions and choices, interventions and services can be provided in the person's best interest. I won't dwell on that because we've got a very detailed presentation coming up later from Lorraine around mental capacity. I think it's just important to note that where an adult is engaging with and accepting assessment or support services that are appropriate and sufficient to address care and support needs, including those needs relating to self-neglect, then the adult is not demonstrating that they are unable to protect themselves from self-neglect or the risk of it. And in those circumstances, the usual adult assessment and support service provision would be the most proportionate and least intrusive way of addressing the self-neglect risk. So in those circumstances, the duty and need to undertake inquiries under Section 42 of the Care Act will not be triggered or necessary. And I think it's important just to make that distinction. Next slide, please. So there is a consensus in the research on the main characteristics of self-neglect and the approaches that practitioners should take when working with people who are deemed to be self-neglecting. There is, however, less consensus as to why people self-neglect. What we do know is that self-neglect is usually a symptom of other problems, for example, deteriorating health, onset of depression or other mental health need, a response to trauma, change in social networks, economic, financial aspects, personal identity and philosophy. And several overarching themes have been identified in research with people who self-neglect, for example, demotivation, inability to self-care and other factors. Health difficulties, homelessness, loss and social isolation have been repeatedly cited as reasons why care had come to seem comparatively unimportant to a person. This in turn can then impact on self-image, further demotivating an individual and entrenching negative cognitions. Executive dysfunction in terms of the inability to perform activities, for example, of daily living. So even though a person may understand the need and it's seen as significant, when this is accompanied by an inability to recognise unsafe living conditions, then self-neglect may be the result. So the perceptions of people who self-neglect have been less extensively researched, but where they have, emerging themes are pride and self-sufficiency, connectedness to place, possessions, and behaviour that attempts to preserve continuity of their identity and control. Traumatic histories, life-changing events are also often present in individuals' own accounts of their situation. And it's important to differentiate between an inability and unwillingness to care for oneself and the capacity to understand the consequences of the person's actions, really in terms of determinants of how we can best respond and support. So examples of potential self-neglect, consequence, adverse impact on well-being, for example, failing to care for oneself in a way so that health or physical well-being may decline, living in very unclean environment, neglecting household maintenance, therefore creating hazards, poor diet, nutrition, obsessive hoarding, potential fire hazards and risks to mobility and so on. By no means exhausted, but those are the types of behaviours that can impact. It is important to understand, though, that poor environmental and personal hygiene may not necessarily always be as a result of self-neglect. could arise as a result of a cognitive disability, poor eyesight, functional, financial constraints. And in addition, many people, particularly older people, research has found who self-neglect, may lack the ability and or the confidence to come forward to ask for help, and may also lack the support of others who can advocate and speak for them. They may then refuse help or support when offered. Next slide, please. So practice around self-neglect often involves some quite significant ethical dilemmas and challenges. Most notably really is that tension between respecting a person's right to self or determination whilst also upholding the duty to safeguard, protect or safeguard. So we can clearly see, just in terms of respect for autonomy and self-determination, really enshrined in our codes of ethics, within legislation, including the Human Rights Act, also policy context of personalisation, and also philosophies around making safeguarding personal. That then needs to be balanced with a duty to protect and to promote dignity, which is also enshrined in our code of conduct, ethics, and within legislation. In terms of approaches and how to best balance these difficult, scenarios and dilemmas, what has been found is, they're absolutely crucial to have, effective, supervision, peer support, to be able to critically reflect and have discussions from a multi-agency perspective, so that issues can be discussed, dilemmas can be debated from different perspectives, so that options can be evaluated, and then agreement about best practice and approaches with individuals within their circumstances. Next slide, please. So in addition to ethical dilemmas, practitioners also need to navigate what's being found to be shifting responses to engagement and support by people who self-neglect. As we've seen, it's really important that self-neglect is understood in the context of the individual's life experience, which encompasses a whole range of complex interplay between their physical, mental, psychological, environmental factors, which can all have an impact on the person's engagement and response to support. So Bray et al. Have used this particular diagram to highlight the difficulty of engagement that can arise from shifting responses. So that's all the way from one end of the scale, from completely refusing or withdrawing from support, to full acceptance, and then anywhere in between that. But an individual at any point in time can be at any part of on that continuum. And then what can sometimes happen, and what has been found through some of the analysis of the SARS, is that refusal or withdrawal can then be seen as that person, just not wanting to engage with service and support, making a lifestyle choice, and then decisions made that cases will then be closed because no further support can be offered. Whereas what we know from research is what's really important is taking a step back and looking at where a person is in terms of their response to support, not giving up. It's about a gentle persistence, working at building trusting relationships, providing encouragement that's sensitive to the person's feelings and an understanding of their perspectives. Next slide, please. So in terms of interventions, research undertaken by Bray, Orr and Preston Shute really have found that practitioners most commonly cited the following as being the key to effective assessment and really making a positive difference in supporting people who self-neglect. The importance of building trusting relationships, really finding the person, understanding the person. Practitioners having legal literacy, being able to work creatively in terms of how support is delivered, and effective multi-agency working. Interestingly, this research identified that the term self-neglect is in itself, it proved quite controversial in that people sometimes didn't identify with this description of their situation. So as a result, it's important that practitioners seek to negotiate a common ground to understand the individual's own description of their lifestyle, rather than making possible discriminatory value judgments or assumptions about how it can be defined. What specifically emerged from the research was a way of working with people that combined aspects of knowing, being, and doing. So it's about knowing the individual, their unique history, the significance of their self-neglect, complementing professional knowledge resources that the practitioners bring to their work. Such an understanding is achieved through ways of being. That's personal and professional qualities about respect, empathy, honesty, patience, reliability, the ability to be present alongside the person while that trust is built. And then finally, doing professional practice in a way that combines a hands-on and a hands-off approach as appropriate. It's really important. So seeking latitude for agreements, doing things that may make a small difference while negotiating with the person for bigger changes, and then being clear about when intervention becomes necessary. So not surprisingly, given how complex self-neglect is, there's no magic bullets for what works. Just to summarise the key themes that ran through some of the successful interventions within the research: flexibility to fit individual circumstances, negotiation of what the individual might tolerate, and proportionality, to act only to contain the risk rather than to remove it altogether in a way that really preserves respect for autonomy. Importantly, it's really crucial to undertake risk appraisal, which takes into account an individual's preferences, histories, circumstances and lifestyles to achieve that proportional and reasonable tolerance of acceptable risks. Where the risks to a person are high, very serious, the case should not be closed simply because the person to review is an assessment or to accept a plan to minimise a risk associated with specific behaviour. As mentioned previously about the the continue in terms of shifting responses. But in those complex cases where there are significant risks, then a multi-agency approach is really important, really needed, to be able to share information, agree an approach to minimising the impact of specific risks, and then with the ultimate aim of improving the person's well-being. Next slide, please. So if we move on to some of the learning that has come out of the analysis of safeguarding adults reviews, and areas where it's been identified that practice needs to improve, both from an individual perspective around direct practice, but also from an organisational perspective. It's not all of them, but there were many things that were identified. I'm just going to touch on some of the key areas. So firstly, that it was found that really, key is an understanding of history and meaning in relation to the person. The analysis of the SARS where self-neglect was a central feature found in a significant number of cases that referrals were viewed in isolation rather than in the context of a person's previous history, with a lack of consideration of responding to repeating patterns. There was also a lack of a family approach was evident. And we know that family members, significant others, may hold information that might help practitioners to appreciate what's causing or maintaining self-neglect behaviour, including the reluctance to accept help. So it's important, therefore, that practitioners engage with family members who provide support, especially when they are requesting help. Equally, however, there might be complex how should we say, codependent dynamics between caregivers and those that they're caring for, perhaps, involving abuse or neglect. Carers assessments are really important and should be offered and be thorough, exploring the willingness, ability to cope and any evidence of difficulties and neglect. Mental capacity assessment, analysis of the SARS really found some significant failings with respect to mental capacity. I think by far dominated, the findings where practice needed to be improved. Some of the things were practitioners not recording which decisions the individual was assessed as having capacity, or to consider the impact of executive brain function. Also, in a significant number of cases, capacity was wrongly presumed or assumed. Recommendations from the analysis included the need to provide, guidance for staff working with people, particularly who have capacity, but engage in behaviours that place themselves or others at risk of harm, and who are refusing to accept support. And it was the importance about recording capacity at the point of service refusal. Such work, may require practitioners really to challenge their own assumptions about lifestyle choice and capacity, and then the impact of the ethic principles within the Mental Capacity Act, assumption of capacity, and so on, and associated notions around autonomy. Another big area that was found to be lacking was a lack of professional curiosity. Practitioners really accepting of circumstances at face value without exploring deeper meanings. So, for example, when we've talked about non-engagement, a key message is to look at the possible explanations. So simply sending out letters, for example, expecting people to actively opt in to support, and then closing a case when no response has been received is insufficient. So it's about using different strategies to engage following missed appointments and monitoring cases through documented, for example, multi-agency meetings or at-risk pathways, risk enablement panels, and so on. A lack of true person-centered approach, which is really critical, to establish trust, appreciate the reasons behind self-neglect, exploring perspective, preferred options with people, offering support wherever possible, negotiating any support that's provided. But importantly, what was found is a person-centered approach shouldn't exclude expressions of concerned curiosity. It doesn't mean person-centered approach doesn't mean avoiding difficult conversations, including respectful challenge around decisions. However, it was found that practitioners often, struggled in some of these cases to have those difficult conversations due to lacking confidence and knowledge around self-neglect issues. So I'd also focus very much on lack of robust and holistic risk assessments. So risks need to be considered individually, collectively, culminating with really robust management plans. The analysis highlighted the importance of a multi-agency approach, including discussion of how self-neglect is viewed. Assessment should be evidence-based, drawing on all available information rather than relying solely on a person's self-report. Risks to other people shouldn't be underestimated. That was found out to be, a critical factor. And assessment should be more broadly configured rather than narrowly. So it's not just concentrating on presenting problems on what's visible, and all legal options need to be considered to support risk management plans. Subsequent care planning and support planning should really build on completed assessments, but the analysis did find that care plans don't always meet professional standards in terms of specificity and outcomes, and nor were they always followed through. Silo working was also identified as being a problem. Lack of consulting with other professionals and agencies negatively impacted on the support offered and sometimes left people in harm. People tended to be referred back and forth through revolving agency doors rather than sharing a range of perspectives amongst professionals to inform integrated risk assessments and management plans. Awareness was found lacking of what different agencies could actually contribute to safeguarding, with assessments all too often completed in isolation and adopting a narrow focus. So this means that approaches were uncoordinated and disjointed, with services failing to communicate, to deliver timely provision, or to clarify their respective roles and responsibility. There was also an absence of strategy meetings, which meant that there was no overall analysis of the known information, no shared agreed approach to assessment, case management, or contingency planning. I think in terms of sharing of information as well, effective working depends on information sharing between agencies, community, secondary healthcare settings, district nurses, GPs, police, children's and adult services, and so on. However, it was frequently found to be poor, resulting in no shared understanding of risks, for example, arising from non-engagement or any agreed multi-agency approach, culminating in really missed assessment opportunities and disjointed, or in the worst case scenario, delayed or no service provision provided. Legal literacy was also found to be a factor, and it was found that staff require a better understanding of legal options. There was variable knowledge of mental capacity. Mental health legislation was specifically highlighted as poor, and other reviews had concluded that there were failures to seek legal advice, to appreciate circumstances when the right to private and family life can be qualified in order to share information and to understand care and support assessments. Safeguarding literacy was also felt to be lacking in terms of poor management, investigation of safeguarding alerts, failure to follow procedures, delays in raising or following up concerns, and poor communication about levels of risk. Sometimes adult at risk management procedures were poorly understood. Thresholds were misunderstood and were misapplied, or referral information wasn't as you say, triangulated with other available information before decision making on whether to proceed with the safeguarding inquiry. Another significant factor was there was a lack of escalation, for example, by one agency when another agency isn't engaging, and where there were available escalation procedures to use, these were found to be unclear and ineffective, because effective safeguarding depends on agencies challenging each other's decisions as well, when concerns remain, in order that alternative options can be explored. Standards of recording, for example, we've talked about mental capacity and also risk assessments, care plans, and decision-making rationale was also found to be poor. We've already talked about sort of difficulties around service refusal, and so SAR analysis, found quite a number of cases where perceived failure to accept support or to cooperate was a reason to close or reject re-referrals. And certainly a risk assessment should be conducted prior to any termination of involvement, coupled with exploration of what might lie behind refusal to accept care. So practice should avoid generalised assumptions, be able to respond to each person's history, levels of risk, mental capacity, issues around loss, family history and trauma, and so on. But this was a kind of frequent occurrence within the SARS around self-neglect, around somebody withdrawing from support, and then services would also withdraw. So we talked about gentle persistence, skill questioning, and relationship building. So finally, just coming on to some of the other key areas of learning was around those organisational factors, because it's important to view learning from individual practice within the context of the organisation within the practice was taking place. Key features that really impacted upon practice included the impact of organisational change and restructures upon staffing issues, staffing vacancies, high caseloads, availability of experienced practitioners, the impacts of the budget cuts to the availability of care packages, care pathways and or services to address complex and challenging needs. Poor supervision, lack of training and lack of senior management oversight were also constant themes. Poor practice wasn't corrected, risks not discussed, practitioners had insufficient knowledge and or skills for some of the complexities of practice that they were encountering, including, understanding the organisation's own procedures. Robust reviews and oversight were quite frequently absent, with patchy performance monitoring and inadequate responses to staff when staff raised concern about feeling anxious or powerless in relation to risks of foreseeable harm. So what clear recommendations to come out is that staff really need to be supported to manage complex cases, including, being able to seek support from specialist practitioners, for example, mental health, mental capacity and law specialists, so that all options are considered. And staff must be able to put their knowledge and skills acquired in training into practice. But the SAR analysis really did emphasise the importance of workplace as well as workforce development. I think evidence was also found that continues to suggest that even when there's available procedures that they weren't used, for example, in convening multi-agency meetings regarding adults at risk of harm. So there was recommendations about policies, systems for supervision, staff support across agencies and so on. And also recommendations made for, considering co-working of complex cases and the allocation of self-neglect work to experienced workers with sufficient training, qualifications and resilience. So that really kind of gives an overview. There was lots more recommendations. That just kind of gives an overview. Slide 8, please. So finally from me then, I suppose it's just some key questions for you to take away back to your own organisations to consider some of the findings and the recommendations from the SAR analysis. Really, some of the key questions are: do you actually recognise any of the features of these service systems in your own work environment, your own organisation, and other organisations within your safeguarding partnerships? What checks and balances are in place to mitigate some of these features? How can you apply the learning yourselves within your organisation from the recommendations that have come out from the SAR and the learning outcomes? And then what local changes do you feel could perhaps prevent similar outcomes within your own authorities? I hope that's just given some flavour and an overview and set the scene before I now hand you over to Sarah, who's going to talk about Mrs. M.
Thank you very much indeed, Victoria. That was so much information packed into a really short amount of time. And we'll be touching on, I know that we'll be touching on some of those issues in this part of the presentation and in Lorraine's. So let's talk about Mrs. M. Mrs. M died of COVID on the 21st of December last year. Cutting a very long story short, which I will fill in the gaps for shortly, she did end up living in a care setting, and they managed to keep her safe all that time. And then she ended up in hospital and died of COVID. So this is in memory of her. It's very, very important that we don't lose her story. So can I have the next slide, Giovanni, please? So let's just hear a little bit about her. Who was she? When we first, it's not actually when we first came across her, we had known of Mrs. M in the local authority before this date. But when she first very significantly came to my attention, she was 72 years old. That was back in 2017. She'd had 32 years in her home, and she owned her own home. And I'm sure many of you will recognise the challenges that that brings. She had a very, very good relationship with her attached neighbours. They were good friends. They spent time together. They had shared each other's families, went to each other's family occasions, went out buying plants together, and enjoyed a very good relationship. She had a house and a garden that was well looked after, and her husband died in 2005. And her neighbours identify a steady decline for Mrs. M from that point, and we've already heard about the connection with significant life events and its impact on people who self-neglect. She stopped allowing people into her house from about 2014, and she had many health difficulties that we were aware of. So diverticulitis was one, narcolepsy another. She was very, very paranoid about one of her neighbours, who she believed was the reason why she ended up being sectioned under the Mental Health Act and why her house ended up being in a mess. And latterly, we discovered that she had diabetes. So that threw a whole different dimension on some of the things that we'll talk about as we understand a bit more about Mrs. M. So the next slide, Giovanni, please. So we came to hear of her, and we came to know of that information that I've just given you because we had a letter. And the reason I've put that detail in brackets there is it just shows how much information we were provided with. And we were written to by the daughter of Mrs. M's attached neighbours. She was very, very concerned about the safety of her parents because of the condition of the house. So it reached me via our housing services manager, who sent me the letter. I had a look at our records and found that she was open to a social worker without trying to make contact with her, and had tried to do that by making numerous telephone calls. So pretty much as soon as I finished reading the letter, I instructed somebody from the safeguarding team to go out with somebody from the social work team and visit the environment and try and get hold of her. The letter described a lot of information, but also described the fact that she'd been subject to Section 2 of the Mental Health Act about 12 weeks before this letter was written. She was discharged home. It was a very, very short stay. The full 28 days for assessment wasn't utilised to undertake the assessment. And when she arrived home from the hospital, she knocked on the neighbour's door loudly and vociferously because she couldn't get into a property, claiming that she didn't have the right key. The neighbours spent some hours with her. They took her to the police station. The police had seized the keys and made the property safe by turning the electricity off because they were so concerned about the state of the property when they went out to her house while she was in hospital. I'm assuming from that nobody really knew that the police had got the keys, so she wouldn't be able to get back in. Anyway, she did end up with her key. And actually what they found by the time they'd spent 3 hours in the police station was that she had the right key. The neighbours went home with her, tried the key in the door, and it opened first time. So of course we can already start to see some issues there beyond the health issues that we already know that might cause us to think that there's something cognitive perhaps going on here. I'll have the next slide, please. And this is what we knew then. So these are pictures. The pictures that you'll see throughout this presentation are of Mrs. M's home. These are not particularly great quality, so excuse that. But these are the pictures that we had in our possession back in 2012. And as you can see, anybody looking at those pictures would probably have a lot of cause for concern about what the whole house looked like. So that's what we knew at that point. Next slide, Giovanni, thank you. So the staff that went out did make contact with her. They made contact with her the next day. They only managed to get her to talk to them through the window. And what she often used to say was, oh, it's not convenient to come in now. Can you pop back tomorrow? And this was an excuse that she used on a regular basis. And this is what she told staff. So she was getting food and drink delivered. She can get up and down the stairs. She can manage to get to the toilet on her own. And she engaged very well with the staff on a number of topics. And arrangements were made to visit her the next day. With some success, it has to be said. They managed to get to see her. She opened the door and they managed to get into the hallway to see her. Okay, we'll have the next slide then, please, Giovanni. So I need to fast forward because this is a very long and protracted story that obviously goes way back before 2017. There were many, many attempts to engage Mrs. M. The two professionals that went out at my request continued to try and engage with her, but she very, very regularly made excuses and gave lots and lots of reasons why she couldn't see the staff. Lots of family, well, there weren't lots of family actually, but the family that she did have were also involved in making attempts to support her and get her to engage. They were also very concerned about her. She used to have very good relationships with the family, but I think as she stopped letting people into her house, things started to deteriorate. And I know with her nephew, at one point, he had made some progress and managed to help her clear the hallway and the stairway. But she was incredibly angry with him about that, denying knowledge that it happened, and the relationship was very difficult for them when they were trying to support her, and it felt to them as if their efforts were being thrown back in their face. We managed to get the GP to go and see her, but she would only allow the GP in just by opening the door a couple of inches. So this went on for a long time. And even in December 2017, so that's a full calendar year, we still hadn't been in the house and we still hadn't seen the extent of the conditions that the house was in and that she was living in. Or had proper eyes on her, really. We saw her through a window upstairs, so that means we can see her head and the top and perhaps her shoulders. Through the crack in a door, we still can't get a full look at what she's wearing, what state she appears to be in. So we had a very, very significant number of multi-agency meetings and started to talk to legal about what possible interventions there may be to get into the house, because what we recognised was the need to see the house in its entirety in order to really understand the risks, not only the risks to her, but the risks that had also been flagged for the attached neighbours next door. And again, this is, repeating some of the things that came out that have been summarised by Victoria earlier on. So the GP and the social worker go out. GP is of the opinion that she's got capacity. Mrs. M was very, very good at holding a conversation with you. I met Mrs. M a couple of times, and she was absolutely fascinating because she could talk to you about bird watching. She could talk to you about her hobbies of crafting and her passion for that. And She would talk to you about how she liked to cook and how there was nothing really wrong with the house. So the conversation flowed very, very fluently. However, on June the 18th, in June 2018, because the concerns continued, because we'd still not had access to the house, we were concerned about her lack of engagement. We were concerned actually about whether she had capacity or not. A 135 warrant was obtained, which meant that under the Mental Health Act, we could go into her environment, into her home, and remove her for assessment under the Mental Health Act. So with that mental capacity assessment, there were two separate mental capacity assessments, one done by the GP and one done by her social worker at the time, both reaching the same conclusion, that she had capacity. Having been involved in the case since 2017, up until last summer, I think it became quite clear to me that one of the things that people had done, and again Victoria made this point, and I know Lorraine will make it again, people went by what she was telling them. They didn't really look at all the other evidence and information in order to reach their professional judgment about capacity, and it's something that we need to explore in a great deal of detail later on. So I'll have the next slide, Giovanni, please. Okay, so we started considering going to the Court of Protection from June 2018. Now, we know that the warrant had been issued, the 135 warrant, and it took a long time to actually get somebody to get into the house and execute that warrant. So what we found is we had to have lots of regularly challenging discussions about why that why that warrant wasn't executed. So she goes into hospital eventually under a Section 2, and she appeals her Section 2. The Mental Health Trust also found no evidence of any form of mental disorder, and we had a new mental capacity assessment start on the 20th of June 2018, and this was undertaken by a new social worker on the basis that the previous social worker had left to go to another role. And that assessment was done very differently. That assessment was done by kind of talking to family, talking to friends, using the observations of the environment, the old photographs that we did have, to give us a sense of whether she could actually do what she was telling us she could do, if that makes sense. I hope it does. And at the point that we were at that time, there was quite a lot of emphasis on making sure that she should go into residential care. And I had a problem with that, I have to say. So I stepped in a little bit and, put my toes in the water again, because I'd stepped out a bit at that point. And I was concerned that we weren't considering other more proportionate options. So I was concerned that she hadn't had any opportunity to be tested out at home in a clean and clear environment to see whether, she would respond well to that. So anyway, the work started on the mental capacity assessment in June, and concluded actually that she lacked capacity. And she lacked capacity based on the following points. She couldn't understand the information, and that was she could not understand that she was living in an environment that was causing her health to deteriorate, was potentially a danger to her and potentially a danger to others. But also she couldn't use and weigh any of that information in order to make a decision to help her understand her care needs, her care and support needs, in relation to helping her maintain a safe environment and her hoarding behaviour. So bear in mind that at that point, the Mental Health Trust was saying there's no mental disorder here. Can we move on? We went to meet with the ward on the 21st of June. She was still in at that point. And we wanted to share the information that we'd gathered through our inquiries and through our mental capacity assessment. So we were aware that they were considering that there was no mental disorder, that she had capacity, but we wanted them to understand our perspective. So we went to meet with the psychiatrist and the ward staff to make sure that they'd got all of the information and they were appraised of all the concerns that we had. Now, one of the things that we did was, after lots of considerations of different legal options and legal ways of doing this, we wanted to really understand what the whole property was like, and up until this point, as you know, we hadn't been able to do that. So we considered housing powers, ruled those out, and what we did was make a best interest decision on the basis that our assessment said she lacked capacity, to use our powers under Section 47 of the Care Act to protect her property and make sure it was safe. And in doing that, housing went out to undertake that piece of work, took pictures throughout the house so that we could really understand the situation. So we sent the Mental Capacity Act and the pictures to the ward. One of the things that we'd also done is requested a delay in the Mental Health Tribunal to allow us to get to the Court of Protection, because we were very, very well aware by this point that because Mrs. M was very, very believable, it was likely to succeed in her appeal against the Section 2, and we were very concerned about her going back to the environment and living for very much longer in it because it was so unsafe. That was declined by the people that organised the tribunal. We also offered her various informal choices as well, obviously, because we didn't want to jump to draconian measures of A, care home first, B, telling her she's got to go and live somewhere else. She'd got to understand all the options available to her. So we offered her temporary stays, temporary support while we made the accommodation safe, and that she didn't accept any of those. So on the 27th of June, we went to the Court of Protection for an urgent hearing. Okay, and we'll move on. The hearing found that she lacked capacity. So she lacked capacity to conduct proceedings. She lacked capacity to make decisions in regard to her residence, her care and treatment, and how to manage her home environment and keep it fit for occupation. And what we managed to achieve through the court is permission, should she be successful in appealing a Section 2, to convey her to the care home, to enter her property and render it safe for occupation. So that was the result of the first urgent Court of Protection hearing. And the next one, Giovanni, please. Okay, these are some of the photographs that were taken by our housing colleagues. We've got one of our housing colleagues on the call for question and answer panel if you've got any questions. This was her bedroom. She sometimes slept in her bedroom, but we'll move on to the next pictures. This was her hallway and her staircase. Lots of parcels, you'll notice. She did a lot of spending on QVC. I was going to say CQC then. Can't spend on CQC, can you? So that's the hallway and the stairs, and as you can see, pose a considerable threat and a significant impairment to her being able to leave that house should she need to escape it. And the next pictures, please. This is Mrs. M's kitchen, and she would be very convincing about how she liked to cook, how she would eat pizza. Paul and I went to the house at one point, and once we couldn't get into the kitchen, is the first thing to say. But actually, once we had managed to clear some of the stuff out of the kitchen and got into fridges, freezers, we found craft items, food packages that were 10 years old, a whole range of things. But this was clearly not a kitchen that anybody would ever be able to cook anything in or prepare food in a hygienic way. And the next picture, please. And this is the lounge. And Mrs. M used to sleep in the lounge quite a lot. She slept on that settee that you can see at the back of the room there, surrounded either on or surrounded by all of the stuff that you can see there. And she would spend lots and lots of time awake through the night ordering packages. She would repeat order lots of different things, ordered plants. And if we go to the next set of pictures, couple of examples of her purchases. We found a number of exercise machines. We found the drill there, the vacuum cleaner, and as you can guess from the pictures, they were clearly things that were never ever put to use. So really, I mean, there are many more pictures than this. This went to our evidence bundle that went to the Court of Protection, and in some rooms there was hoarding to the ceiling. So her crafting equipment that she used to talk about, we found in boxes in one of the spare bedrooms that went up to the ceiling. Okay, let's move on. So, as we expected then, Mrs. M did appeal her Section 2. What we had done on the day of her tribunal was went to the ward. Obviously, we had the court order by then, and we arranged for the ward to bring Mrs. M out of the ward down a certain route that would bring her past us so we could convey her, get her into the car. Obviously, we knew that we would need some persuasion and then take her to the care home. But that didn't happen. So the ward took her back to the ward, and then we had to go to the ward to try and persuade her to get out of the ward and into the car. And in fact, we managed to do that with the help of a member of ward staff who had built a very good relationship with her. So the tribunal judge, this is the Mental Health Act tribunal judge, asked for the following to be passed to the Court of Protection: that they disagreed with the order that we'd sought, and that there's psychiatrists in the hospital had found her to have capacity. So, as I say, much persuasion and the help of a significant member of staff, we managed to get her to a care home on the same day. Two members of staff that had been into the home while Mrs. M was in hospital had reported signs of diarrhea and vomiting. The nephew then proceeded with in consultation with Mrs. M to start to work through clearing the house of all the rottable rubbish, making sure that, you know, she had some choice about the colours of the walls, the carpets that she wanted. But then when anybody spoke to her about what had been happening and what was happening to her house, she denied any involvement with any of those decisions. So there's ever such a lot of the story that I'm missing out here. We were in very protracted Court of Protection proceedings, and that was for a number of reasons. There was a very significant delay in appointing an official solicitor, and there was a real disagreement about the way forward. So at that point, we were pushing to get her home with a decent support package to try and make sure that she'd been given every opportunity to succeed at home. And the official solicitor actually ended up blocking that. So we were in this really kind of ironic position where we were arguing to get a home and the official solicitor was reluctant to allow a home because they wanted more tests and more mental capacity at work done. In fact, they did instruct an independent mental capacity assessment, and that did conclude that she had lacked capacity and had a hoarding disorder. So if we can move on to the next slide. So when we got Mrs. M to the care home, there was a very short period where she was engaging with some of the staff and some of the residents and leaving a room. But actually, it didn't take very long for her to withdraw to a room, and that's exactly what happened in her house. She continued to hoard. She always promised to sort through the bags that the family had arranged to take bags to her for her to sort through, try to keep her involved in the process. And then things just gradually got worse. So the hoarding got worse. She urinated in containers that were in her room as opposed to the ensuite that was next to her bed. She continued to talk about how she loved crafting, but didn't actually engage in any of those activities that were happening in the care home. She used to eat all her meals in one go. She ate chocolates, cheese, other processed food. And of course, we didn't know at that point that she'd got diabetes. So that became something else we had to try and understand. You know, how much did she understand about the diabetes? And she claims that she knew about it. She wouldn't take any treatment. She said that she would manage it through diet. Now, clearly we knew from her actions that she wasn't managing it through diet and wouldn't manage it through diet. We also knew that despite her many attempts at saying to us she was going to sort the house out and she was going to get the car sorted, etc., she wasn't ever going to do that. She was supported to do that through the care home, through the support of her social worker and Alistair, who's on the call as a safeguarding practitioner, but would never take those opportunities to do that. And the next slide, please, Jiminy. So she remained in the care home. As I said, the independent expert did confirm that she lacked capacity and had a hoarding disorder. And that is a diagnosis in OCD-11, our current diagnostic tool in use in British Psychiatric Services. And I've highlighted this particular bullet point in yellow for you because this is a comment made by her social worker who wasn't able to join us for the question and answer panel today, but he felt very strongly that what we ought to be doing was really making space for that therapeutic process. I'm describing the process that we went through for you, but actually there was a hell of a lot of work going on behind the scenes. So certainly one of my recommendations to you as the audience is that if you're dealing with somebody who is hoarding or self-neglecting to this extent, to this level of risk, then you must make space to build that relationship, to try and work therapeutically with the person to get them to address those issues. We eventually managed to secure the involvement of a psychologist, and this was really probably getting on for a couple of years after. So I think probably around 2019 we're looking at now. She'd identified issues with her memory that wasn't picked up during the hospital admission. Her language was good, and that explained why she was so convincing, so easy to talk to. And the tests that the psychologist was using indicated planning being a really significant problem. So that really explained why she would say she would do something, but then couldn't actually make that happen. We, at that point, changed our position. So we no longer, in our court processes, were saying that we would support her going home. We believed that because of the behaviour and the actions we'd seen, what we'd seen of her in the care home, meant that she couldn't safely be supported at home. And our request of the court was that she remained in the care home. So if we move on, I can't remember if that's my last, that was my last slide. So just before I hand over to Lorraine, that's obviously a very shortened version of Mrs. M, but I'll never forget Mrs. M, actually, and I think I learned a great deal from working with that situation. I know the people that worked alongside me also learned a lot, and I hope that some of the insight into the process that we had to go through has helped you in your work as well. So I'm going to hand over to Lorraine now.
Thank you. It's all gone quiet in my house, so I'm hoping that the banging continues to be stopped. Hi, I feel a little bit like I'm coming along to state the obvious after the really interesting presentations that you've had. So I've not called this assessing mental capacity around around self-neglect, but because much of what I'm going to say applies in a number of complex situations. So I'm just going to pick out the areas really when assessing capacity is not straightforward. Next slide, please. So I think it is important that we start by reminding ourselves, Victoria talked at the beginning about this balance between promoting personal autonomy, but also the protection need as well. And we've got to get that in balance. And this is a really useful quote that reminds us of that, that the presumption of capacity is important because it ensures proper respect for personal autonomy by requiring any decision as to a lack of capacity to be based on evidence. Yet this presumption, like any other, does have logical limits. Where there is good reason for cause for concern, legitimate doubt as to capacity, the presumption cannot be used to avoid taking responsibility for assessing and determining capacity. To do that would be to fail to respect personal autonomy in a different way. So one of the things that I generally say on our training on assessing capacity is there's two mistakes people can make, either over assessing or over assuming, you know, and it's important that we do start with a presumption of capacity, but where there is good reason for concern, that we then carry out an evidence-based assessment to rebut that presumption of capacity. Next slide, please. So I'm just going to sit this in some of the basic principles. But for me, what you will know about assessing capacity is that it's a functional test. And I think for people like Mrs. M and the description that you've heard, it's not an intelligence test. It's not an articulate answer test. It's a functional test. And the person's functioning is tested by asking ourselves 4 functional questions. Can the person understand the information relevant to the decision? So that's about the functioning of their understanding. Can the person retain this information long enough to make a decision? Can the person use and weigh this information in order to make a decision? And then if they could make that decision, would they be able to communicate it? So we're asking 4 functional questions, and I know I'm re-emphasising, but there's a real importance in just understanding that it is functional. Okay, next slide, please. So what I'm really going to focus on, I'm not saying that retaining of information isn't important, but I'm going to look really at understanding and using and weighing. So next slide, please. When we start to think about this functional test of understanding, that in order to make sure we've always got the balance right between autonomy and empowerment and protection, the level of understanding must not be set too high. So we know that we mustn't set the bar higher for those people where capacity is questioned than we do for those whose capacity isn't in doubt. So we know that there is a sort of a requirement that we don't, if you like, engineer a capacity assessment in order to make sure the person fails. Equally, we mustn't start with a blank canvas. So I think it was Sarah who said that we needed to know what the options were in order to put those to Mrs. M in order that she could then evaluate the options. So again, we can't start our capacity assessment with a blank canvas. Next slide, please. So the very important, simple, straightforward thing that we do when we're doing a capacity assessment is we work out what the decision is that needs to be made or the action that needs to be taken. We work out how we can give the information relevant to that decision. And then we look at how we're going to know and test whether that information's been understood. So there are some problems that can occur with that, and I'll say a little bit more about that in a minute. But in essence, that's what we're doing. What's the decision this person needs to make? What would anybody need in order to make that decision, and how can I give them that information? And then how can I test that that information's been understood? Next slide, please. Then the person needs to demonstrate their ability to use and weigh that information. Next slide, please. So use and weigh has been described as the capacity to actually engage in the decision-making process itself. The ability to be able to see the various parts of the argument and to relate one to another. So we've been presented with information. We need to understand that information, and then we need to be able to do something with it. Now I've got this information, I need to weigh up the various options, the reasonably foreseeable consequences of reaching a decision or of failing to reach a decision. And we need to be able to kind of do something active with that this process of using or weighing. Next slide, please. So there are some things that we need to be aware of here when we're looking at whether somebody can use and weigh information. We as professionals need to be aware of the danger of equating an irrational decision with the inability to make one. People can and do make irrational decisions. We make irrational decisions. That doesn't mean that they lack capacity. So we need to always have this set of measures really in our thinking, that just because this might be an irrational decision, just because it actually might be the wrong decision, doesn't mean it's an incapacitous one. Sometimes someone might not agree with the advice of professionals, but again, that doesn't mean that they lack capacity to make a decision. So we need to be really, really aware of this tension. And I love this quote. I haven't given the reference for it, perhaps I should have. There's a space between an unwise decision and one which an individual does not have the mental capacity to take, and it's important to respect that space and ensure it's preserved, because it is within that space that an individual's autonomy operates. So what is right for one person is not right for another one, and we are protecting always that unique individual autonomy. Next slide, please. So when we're looking at using and weighing, it involves some weighing by us of those who appear to be able to talk the talk but not walk the walk. It involves looking at whether the person can use the information but actually chooses to disregard it, or whether in fact they can't use that information. So again, this is another tension. So someone may be able to use the information. I've heard what you've said. I understand that that means if I do this, that will happen. If I do this, that will happen. But I don't care because I'm going to do that anyway. That's a demonstration of using and weighing. But someone who says, no, you know, as in a very similar case to Mrs. M, the person said, oh, the doctor left the door open and that's how the mice got in that are living in my chair. You know, they're just not able to use and weigh and ignore that information. It also involves, as Victoria said earlier, the person's values and their life story. So it would be very easy, particularly in some of these self-neglect type situations, to impose a value judgment, perhaps because somebody doesn't live how we think they ought to live. Then it involves knowing something about the person's values, the difference between someone who's perhaps always lived a slightly lifestyle a bit on the edge, and somebody, as you heard Sarah say, in this case, I've forgotten the date, I'm sorry, but lived perfectly, kind of kept the house very nice and the garden very nice until a certain date, when, because of a bereavement, things started to change. And also when we're looking at using and weighing, it involves a wider conversation, because they may just simply not value what we value. You know, and we see this often when we're looking at people resistant to personal care, perhaps in a care home, and you look and you think, you know, when they were at home, maybe they had a shower once a week, and here's this person in a care home trying to convince them for some reason that they have to have a shower every day. Next slide, please. So the question, I suppose, that I'm trying to tease out is, I've made it perhaps sound very easy. So if it's that easy, why is it so hard? If what we're looking at is approaching a person with a functional test, and that functional test is split over 4 areas, can the person understand the relevant information? Can they retain it? Can they use and weigh it? And can they communicate their decision? So if it's so easy, why is it so hard? Why did we get, perhaps in this case, I think it was 2 capacity assessments that said she had capacity, and then 1 that said she didn't, and then a challenge even from mental health colleagues saying, but 2 psychiatrists say she does, and then finally the court and the court's expert saying she doesn't. Next slide, please. So I think some of these challenges start very simply to fall apart at the beginning. If we fail to get the question right, then we are not going to present the right information to be understood, and it can start to fall apart from there. So it was described quite nicely on Sarah's slide: capacity around care, capacity around residence, and capacity around, I've forgotten exactly how it was phrased, but it was very nice and succinct. It was about accepting support in order to manage hoarding behaviours, something like that. So it's getting that question right. Exactly what is it that I'm looking to assess with this person? What is the question? And actually spend time there, and don't think that that's just a daft thing to focus on, because it isn't. It's where this all starts. And if you don't know what the question is, then how do you know what somebody needs to understand? And if you don't know what the question is, and you don't know what somebody needs to understand, then how can you know they've had the relevant information, particularly when you're faced with a person who's very articulate, very intelligent, can have conversations about any number of things, but may have a particular area where, for whatever reason, I'm not going to try and offer a psychoanalysis, but for whatever reason, that particular area, they are unable to understand. Next slide, please. So getting the decision right. Sometimes people do understand perfectly well. So understanding, I mean, in this case, we heard that actually the expert found that she didn't understand, and she wasn't able to use and weigh. But sometimes the person can understand perfectly well. So the problem or the challenge is not in knowing, but it's in doing. So that person who can say, yes, I understand, they can explain all of those things, and then the next moment they're doing completely the thing they've just said that they're not going to do. Or they have just told you in a face-to-face conversation the strategies that they're going to employ when they lose their temper, or when they become anxious or angry, and a second later they may be becoming anxious or angry, and so on. So then they understand, they can have a conversation with you, they can give you completely what we might call the right answers, but in the moment, in the situation, and in practice, they're not able to do that. So to some extent, Mrs. M was giving the right answer about what she was eating, the food she was cooking, how she was going about doing some of these things in her daily life. She actually wasn't doing any of them. So taking you right back to the start, this is a functional test. How was she functionally applying that information that she'd understood? Sorry, there's lots of things popping up and it's quite hard to ignore them. So this, sometimes where people understand very well, this leads to a challenge of thinking through, is this an unwise decision or is it an incapacitous decision? And all too often I find that people fall back on the unwise. It's just an unwise decision. And it's not a good place to stop, because that needs further interrogation. Because if somebody who is able to give the right answers is not applying them, is it unwise, or is it more about their ability to use and weigh? Next slide, please. So it's almost like I planned it there, isn't it? Move straight on from understand to use and weigh. So the ability to use and weigh is crucial. The person who gives you their view, which is different than the professional's view, which may even be completely the wrong view, but are fully aware of the risks, is very different than the person who gives great answers, demonstrating great understanding, but when they're in certain situations or certain heightened states, or simply even in the situation, cannot carry out any of what they've described. And the question to you guys is, how are you going to know that? If your interview is the only way that you gather evidence for a capacity assessment, then it will not be sustainable in these complex situations, because in these complex situations, you need to see evidence of the doing, not just the saying, or it's not going to lead you to a robust enough capacity assessment. Next slide, please. So if a person is able to use and weigh the relevant information, the weight to be attached to that information in the decision-making process is a matter for that person. So a person who can use and weigh, but says simply, I just don't care, that's not important to me. And I'm thinking of one of the cases you may have read about some time back about, it was publicised as the woman who lost her sparkle. And this was a woman who refused treatment for cancer because she was a very gregarious woman, a very attractive woman. She'd had a number of husbands and partners, and she quite openly said she'd married for money and she enjoyed spending money and so on. And she said that if she had this treatment, it would mean she'd lost her sparkle and she didn't want to live like that. And the outcome was that she had capacity to make that decision, which she did do, and she did die as a result of not having the treatment. But she was able to take those risks, take that information, understand the risk, but actually give it no weight. So that is one option, but you need to be then very careful when assessing capacity to make sure that you're not confusing a value judgment. Oh, that's the wrong decision to make. Everybody should have treatment for cancer, with a functional inability to use and weigh. So your assessment and conversation should gather values and life story as you're going along. Next slide, please. Another common area of difficulty is where a person gives superficially coherent answers to questions, but it is clear from their actions that they're unable to carry these into effect. We seem to be finding in many situations people who have been assessed to death. They've been over-assessed, so they've learned the language of mental capacity. It's no longer the remit of professionals, it's the remit of everyone, and they are able to learn. I was made aware of an assessment only in the last week with a young woman with some very, very risky behaviour, who was able to talk about the foreseeable consequences, the reasonably foreseeable consequences of her actions. She'd Googled and read about the Mental Capacity Act, and she'd learned a set of information, but was totally and utterly unable, when dysregulated, to put that into action. So it may be that there's also evidence that they cannot bring to mind the relevant information at the point when they might need to implement it. So at that point, the information that they've totally discussed with you, they're unable to bring forward. And that might be because of executive dysfunction. So the ability to think, act and solve problems, including the functions of the brain which help us learn new information and remember and retrieve that information. So we see this particularly in brain injury, some sort of frontal lobe impairments, where again the person in situ cannot bring into that situation the information that they have completely and utterly been able to understand. Next slide, please. So an important question to ask in terms of thinking that we may be heading towards making a decision around an inability to use and weigh is looking at whether the person's aware of their own deficits. A person who can actually understand and use and weigh the fact that there is a mismatch between how they respond to questions in the abstract and how they put them into action in the concrete situation. You may even be heading more to a capacitous decision if they say, yeah, I know I've got difficulty with that. I know that it's easy for me to say, but actually I struggle with doing it. You know, that's giving you slightly more of a kind of nudge towards it being a capacitous decision, because they're aware of some of those deficits, which means in theory that person would accept support. So it gives us somewhere to go. Next slide, please. So failing to carry out a sufficiently detailed capacity assessment in these situations can expose the person to substantial risks. And we heard how mental capacity featured in so many of those STAR, the research that was carried out, how it featured so much in those. If the person cannot understand or use and weigh, they cannot implement what they say that they will do when they need to do it, and they're unable to bring to mind the information needed to implement the decision, they are likely to lack capacity for that decision. And the emphasis really is on how you are going to evidence that. Next slide, please. So where you do have this, what you might call a mismatch, I quite like it really, that phrase. So it's the mismatch between what that formal interview situation might tell you and what the ability of the person to put that into action might tell you. Where you've got that, you need clearly documented evidence of a repeated mismatch. We are all capable of saying, I'm not going to have a cake at lunchtime, and then having a cake at lunchtime. That's just human nature. We're talking about something here that is beyond human nature, because we're talking about something that arises because of a mental impairment. So you need to be sure that you have clearly documented evidence of a repeated mismatch, not just once she told you she could cook, but actually she didn't go in the kitchen that day. What you've got here is somebody who actually would be physically unable to go in the kitchen. So, okay, she might say, I can't get in the kitchen. I know it's a mess, so I order takeout food. Okay, does she order takeout food? You know, there is a much more of an investigative role in these complex situations. And it's unlikely to be on the basis of one assessment alone. So when I say one assessment, I mean one assessment interview. You know, if the assessment is the process of gathering in the evidence, you're not just going to do that on one occasion in these complex situations. You have to explain how the deficits that you've identified and documented relate to the functional tests in the MCA. So next slide, please, which is my last. I hope I'm in time. I think I am. So in conclusion, assessment in these complex situations is often not, I'd probably go as far as to say it is never a one-off matter. Time is needed to undertake the assessment and gather as much evidence as you need to reach a conclusion. Do not be afraid to go for evidence to other sources. And I think sometimes people are. If the person has told you this, how have you checked out whether that's correct? How has that been triangulated? Look at written information. If you've got endless reams, you know, if we were in a paper world, of social work information that tells you one thing and the person's told you something else, you've got a doubt going on there. And then you're speaking to other people who know that person well. It might include additional conversations with the person, corroborative evidence, sometimes observation. Some capacity assessments I've read have been really good, where they've actually observed the person. This is what they've told me. I'm going to observe them in action and see if that's the same. And remembering that your assessment and your conclusion are two different stages. Your assessment is how you're going to gather all of this in. Your conclusion is what you do with it at the end when you've thought it through and you've been through some of the complex thought processes that I've just described, and then you're arriving at a conclusion. Okay, so that is my slides, and I think I'm back over to Sarah and Q&A.
Thanks very much, Lorraine. So much to think about in what you've said. I understand from Emma that we don't have any questions. So whilst and just as I said that, one popped up. So what I was going to say was, while I'm wrapping up, it'll allow you a bit of time to pop some questions in if you've got any to ask. So Emma, would you like to read out the first question?
So the first question is from an anonymous. And it says, what is the role of the INCA in this process?
Oh, okay. Who wants to start with that one? Lorraine, do you want to take that first?
Yeah, probably. It's a good question. I think, I mean, if we look at the various statutory grounds for an INCA change of accommodation, so you might say we've got a statutory ground there to refer to an INCA if there are no family or friends. I have to say I don't know in Mrs M's case whether there were family or friends or not, because I wasn't involved. But clearly, if there were no family or friends, we were talking about a change of accommodation. So the independent mental capacity advocate is a person who really has got a role around supporting a person where we're making best interest decisions. There are statutory times when we have to refer, and change of accommodation is one of them. There's also an option to refer to an INCA where there is safeguarding concerns. So again, that's an optional route that we could choose. So yeah, there may well, I don't know whether we did utilise that route here, or whether it would have made any difference, to be honest. And because we had some challenges around does she or doesn't she have capacity, we might have actually had another hurdle to climb in convincing the INCA that the person lacked capacity for the decision. But it's certainly a good reminder that advocacy is always, someone who is there, who is going to be able to represent the person's views in this process. It's certainly eyes and ears. Whether they would have got in or got any nearer, I don't know.
Okay, Emma, have we got any more questions?
We do, yes. We have another question again from an anonymous, and it is, I'm interested in how Mrs. M's case was managed when she was a homeowner, therefore potentially self-funding for home support, clearance, residential fees.
Okay. I'm quite happy to pick that up, and Alistair may want to chip in. In a way, from my point of view, it was quite simple. We were never able to get an understanding of what Mrs. M's financial position was. I'll ask Paul to comment on the homeowner element, because clearly that was quite an issue when we first started working with her, and remained an issue all the way through the situation with Mrs. M. But in terms of our provision of the residential care, she was assessed under the Care Act. She had eligible needs. It's difficult to remember now because it's a couple of years on, or a year or so on, but I wouldn't mind betting she would have refused to pay the residential care fees. So the local authority paid for them in recognition that she had got eligible care needs, and therefore it was our duty to meet those needs. Now, as part of this process, as we've talked about, repeating the number of mental capacity assessments, part of the work was to understand her capacity to manage her finances. And our assessment concluded that she lacked capacity to do that. So we recommended that she had a deputy. So essentially it would have fallen for the deputy to deal with any associated bills, and the local authority at some point, had we have got into that situation, would very well have gone back to the deputy to ask them to pay for the care home fees. But my understanding is we accepted we had to pay it. She'd got eligible needs. It was our duty to meet those needs. So that's how we dealt with that bit. But if I hand over to Paul, Paul, do you want to say something about the challenges of the private home ownership at the start of the process?
Yes, certainly. Thank you, Sarah. Obviously a very complicated case, as you can see. We found that when you're dealing with owner occupiers, they've got the control of their property. You're probably picking up issues from neighbouring properties where they're suffering from obviously lack of enjoyment of the amenity, because they often have overgrown gardens, cars parked on driveways, accumulations of rubbish. So it's those sort of issues that sort of come to bear. So we have powers within the Housing Act, the Public Health Act and Environmental Protection Act that can be brought into play. But obviously we can only use those powers if somebody's got capacity, and where there is capacity and we can use those powers, we can do works in default, but we do try and engage with families, if there are family members or friends, to see if they can do works informally. So there's a whole raft of different angles that we can take, but ultimately we can put charges against the property. But in this case, there was no capacity, and therefore the route was very different, but we supported as a housing department in providing professional expertise on surveying the property, gathering evidence and helping to formulate the reports.
Thanks very much, Paul. Thanks very much, Paul, for that. Emma, we've got a couple more questions coming in, but just before I go to that, I've just been reminded by a colleague of perhaps a clearer message around the finances from a local authority perspective, which is a local authority's primary duty is to meet the assessed needs and worry about costs as a secondary matter. So hopefully that is what I said, but I think Gary's articulated it a bit more clearly than me. Next question, Emma.
So the next question is from Teresa Ricard. I hope I've said that correctly. And she's asking for the panel's thoughts on managing disagreement between mental health services and social care around the Mental Capacity Act. And she's asking particularly, was there a discussion in Mrs. M's case?
I'll take that, and then if Alistair wants to chip in, I'm waiting to see whether I'm getting a nod from him or not. I have to say that working with mental health colleagues around Mrs. M was very, very challenging, and what it required was all of us that were involved to be like dogs with bones and not let them go. It really was a tricky situation. So as you heard in my presentation, we proactively went to the Mental Health Trust to share information. You know, my role in that meeting was not to try and get them to, well, I suppose it was to try and get them to change their mind to a certain extent, but I really wanted them to consider and use all the information that we'd gathered as part of our process, because I thought it would be helpful to them in their assessment of her so that we could get the right treatment. And actually what it required was constant escalation and pushing for services. For instance, it took us a long time to get access to psychological support. And when we finally got to work with the psychologist that was allocated to Mrs. M, she was so beneficial to us. She came up with things that, you know, we would only have dreamed come out of an assessment under Section 2 of the Mental Health Act, if I'm honest. But the opportunity wasn't taken to do that kind of work, which was a real shame. So it was very, very difficult. It requires tenacity. It requires you to continue to be prepared to challenge each other and accept that you can have that professional disagreement. I'd also kind of caution against not preempting what you think your colleagues in mental health are going to think. So, for instance, very, very good support from our mental health social work team colleagues. And her social worker ended up being open to the mental health social work team. That took a little bit of negotiating, but once we'd secured that as the route, because hoarding disorder is a mental illness, we found it incredibly helpful to have their expertise as part of the team that were working to support Mrs. M. Alistair, do you want to chip in about the work with mental health colleagues at all?
Yeah, I'm happy to. I mean, I echo what you say there, Sarah, about getting health colleagues involved, and it was a case of significant amounts of escalation by senior managers. And part of the problem that myself and the mental health social worker found was that there wasn't the services in some respects in relation to hoarding or the experience within the health sector available to us within Shropshire. We were flying around the West Midlands trying to find people who had got specialist training or knowledge around hoarding, but we didn't have that. Because we still had the problem when I was working with Mrs. M, is that she was still hoarding within the residential home environment, and we were at that time, the social worker and I, still trying to work on the basis of trying to get her home, and what did she need to do and be able to do for us to feel that she could safely go home with some form of support. And it was when we got that psychologist involved that opened the social worker and I to have a change of opinion in respect of trying to no longer wishing for her to go home, because we reached the conclusion following the psychologist's input that it just wasn't going to work because she was so entrenched. That's Mrs. M. But so yeah, it was a very challenging situation at that time.
And Sarah, I just wanted to bring in that one of the key findings from the SARS was within the context of safeguarding and self-neglect practice, there was a lack of escalation. So when a particular agency either wasn't engaging or wasn't meeting their responsibilities or taking action when it was felt that action should be taken, then there wasn't appropriate escalation up to senior management level from organisations. Of course, wherever possible, you try to resolve these professional differences in terms of relationship building and so on, but there comes a point when escalation is required. So it's important that organisations do have clear escalation procedures, because one of the issues from the analysis was, as I'd mentioned, that even when procedures were in place, they were unclear and ineffective and they weren't being used.
Thanks very much, Victoria. Thank you very much for that, Victoria. That's a helpful reminder. And I think it's important to say that escalation and challenge doesn't mean that you sit there banging your fists or go straight to the top. You need to resolve it at the lowest level possible. And only when you can't, you go up to the next level through your line management structure. And just out of interest, on a connected but similar matter, the learning coming out of some of our children's safeguarding practice reviews at the moment is about a lack of use of the escalation process in order to get what is required for that person. So I'm sure they found working with us as challenging as we found working with them. It goes both ways, but absolutely at the heart of what we were trying to do was to do the best for her. And that's why we kept going back and kept pushing until the door was open. Emma, any more questions?
There are a couple of follow-up questions just on the basis of what some people have said, so I just wonder if it'd be useful to address those first. Just in relation to Paul's comments around housing, there's just a follow-up question from Alan. Did Paul say that our powers available to take action against homeowners, as we were told by Environmental Health in a very similar case that they can only provide an advisory report?
Okay, can we hand over to Paul?
Yes, I did say we do have the ability to take action against homeowners where they have, or they're deemed to have capacity. Where capacity is in question, then we have to be very careful how we use those statutory powers, and therefore it's all about having those multi-agency meetings, having those conversations with colleagues and doing all the necessary work around the Care Act and capacity assessments to try and work out what is the best approach to support this individual that is often very vulnerable and needs help. So it's approaching something very sensitively. So it could well be, I'm not familiar with the case, but that at that point with the information that's available, that they're suggesting an advisory report on the condition of the property for those conversations to take place and obviously to form an action plan.
Thank you, Paul. Thank you, Paul. I'll come back to you, if you don't mind, Paul, to ask you to be a bit more specific about what powers you have, because I know that when we discussed Mrs. M, we had quite a concern that because of the powers, essentially it meant it would go through criminal proceedings. Have I got that right? Have I remembered that correctly? But if you could say a bit more about what those powers are, I think it would be helpful to the audience. Thank you.
Yeah, certainly. So yeah, we've got a range of powers under the Housing Act 2004. So that's using the Housing Health and Safety Rating System. So that's looking at the condition of a property, its repair, and whether or not there's any hazardous conditions. So we have Category 1 hazards, which have an imminent risk to life. So you could have dangerous electrics. You could have falls between levels if there's no safety guarding on stairs, balustrading. And then you have Category 2 hazards, which are lesser risk, but again need to be taken into account in the round of the general property condition. And then you have hazard awareness notice. So there are some advisories. It's almost like an MOT on the car or a car service. These are things that you should probably look at doing to improve your property. Those powers are primarily used in the private rented sector, and they're used to regulate private rentals and deal with rogue landlords. But those powers are tenure blind, so they apply to owner occupied sector as well. So we use those as a benchmark when we're assessing any properties. Looking more around the accumulation side of things and infestations, so your rodents, we have public health legislation. So we've got the Public Health Acts, and we can look at filthy and verminous premises. So that's a power that we can use to go in to clear up properties, to cleanse them, and we use specialist contractors to do that, have to obtain quotations, and we can charge that back to the property. But again, we're dealing with people that are deemed to have capacity, but that is not something that we can do to deal with the condition of the house. If there's all the cognitive behaviour issues, then that's another bit of support with mental health and social care colleagues. So those are some of the main powers as a general overview.
Thank you, Paul. Thank you very much. Emma, any more questions?
We've got a number of general questions. We've just got one more follow-up question for Mrs. I just wanted, there's been a couple of questions around whether or not the case was for safeguarding adult review, and my understanding is that it wasn't. So no, there was just some positive learning. But the follow-up question was around from Amanda, and it was, can you explain more about how psychology were engaged, as this to me is key?
Well, it was mainly about pushing at the highest level possible to get them to prioritise accepting the referral. So we had to make a referral into our local mental health trust to access psychology services. And what we did was, because we were in the Court of Protection and we'd got some recommendations from the court as for actions that we had to take, we were able to use that as a bit of a lever to go back to the mental health trust to say, we're being instructed by the court that we have to have this psychological input. And that's how we ended up pushing to make sure that that happened in a more timely manner. And I think it's probably fair to say that the whole team, Alistair, Ben, the social worker, myself, we all used and exploited our relationships with the people that we built in different organisations to get the outcome that we wanted. So the court order and what we were required to do through various court orders was definitely helpful in doing that. But as I said, it's just making sure you go into the highest level sometimes to actually get assurance that that priority is going to be given to accepting that referral. And that's what we did for Mrs. M. And it worked very well for us. I'm not convinced that she would have engaged longer term. We'll never know that, unfortunately. And certainly one of the recommendations of the psychologist was to do some work around bereavement with her. And one of the statements, I shall never forget one of the things that she said to me when I went to explain the Court of Protection order to her in hospital. She just said, well, I haven't got anybody to cook for anymore. And it, you know, you could see the impact of the loss of her husband and how it started from that, I think. Emma, any more questions?
Yes, we've got a couple. They're moving into more general questions now. So from an anonymous post, thanks for such a brilliant presentation. What do we do when we know we need more time to make the assessment determination? However, there is immediate need for ensuring safety and removal from home.
That's $1 million question, isn't it? I'll add my 4 pence to that, but I'm pretty sure Victoria or Lorraine might want to also comment on that. For me, it's very much about trying to understand the risks and the imminence of what's going to happen. You do as much as you can to assess the situation in the time that you've got, but actually you've got to be clear about whether there's imminent danger to that person. If there is, and that's what your information is suggesting, that's the point at which you might look to get an urgent recommendation from the court to be able to intervene. It doesn't mean to say that intervention is there for the rest of that person's life. You can always review it as things change, but that would be my initial reaction. But I'm going to hand over to Lorraine, I think, first, and then perhaps ask Victoria if she wants to add in.
Yeah, I agree, Sarah. I think it's okay. The court protection anyway often proceeds on the basis of an interim opinion around capacity. So you may start off saying, we think this person's got capacity, and then the court might conclude, you know, they have or they haven't. So you can start off with kind of what your best guess is, if you like, whilst you're then taking action based on that. Yeah. Courts are 24-hour courts, so you can always get an urgent decision. You won't be popular, but you can always get a decision at any time of day. So I think it's kind of do what you need to do to secure the action you need to secure at that point in time. So it might be that you end up saying, like, I haven't had the time yet to do all of this that Lorraine just told us to do, but my initial response based on this, that and the other is that this person lacks capacity. So you proceed on that basis. You can take actions then in that person's best interest, or you can look at your application to court whilst you're considering, so you can have a kind of at this point in time decision and then a more measured, thorough and work through decision. If that helps.
I'd just add to that, in line with what Lorraine's just said, is that I've written capacity assessments for the Court of Protection where it says to the best of my professional knowledge, and that's especially true when we have people who are declining to engage in conversations, where it's the evidence that we have is based on what they're doing rather than what they're saying.
Thank you, Alistair. I'm just waiting for him to come offline. Victoria, do you want to add in?
The only comment I'd got is just really the importance of recording, really, in terms of rationale for decision making and so on. And as long as that can be justified, based on the evidence, the assessment that's been completed within the time available, but the recording of those decisions are really, really important. Yeah.
Thank you. I just want to add something about the importance of understanding the risks that in the situation that you're talking about. You've got to be very articulate and very clear about what the risks are. So certainly we spent a long time in multi-agency meetings about Mrs. M, pulling that apart. So we would look at what the risks were to Mrs. M, how likely those risks were to happen, and what the consequences of those risks were for her. We did exactly the same exercise in relation to the attached neighbours. What risks were they at? Under what circumstances? What could the consequences be if intervention wasn't taken? And we did it in a number of ways. We looked at risk without taking any intervention and getting involved and what could happen then. And we also looked at risk in terms of, if you put support in and we've got Mrs. M responding, what would happen then? And of course, the risks changed throughout the process, depending on where Mrs. M was, where she was living. So once she wasn't living in a house, we were able to review our risk assessment around the neighbours, because the property was being cleared, it was being cleaned, all the stuff that was worrying them about the fire risk because they'd got a connected shared loft space was eradicated to them. So we were able to reflect that in our notes, and we made very detailed notes of those risk assessment and risk management discussions. Any more questions, Emma?
There is one question that, if there's time, I think would be quite useful too.
Yeah, let's just cover one. I'm hoping we won't just cut out at exactly 4 o'clock.
Okay, so it's from an anonymous post, and it says, an ever-increasing focus on confidentiality and data protection, with the assumption being you can't share anything without permission. Can we automatically override this when permission is withheld, if there are obvious risks to the person, even if they seem to have capacity?
Right, I'm going to give my non-information governance specialist response to that and say yes. GDPR is not a barrier to sharing information. It should not be used as a barrier to sharing information. It describes how and when you share information. So I think, again, you've got to be very clear about risk. You've got to be very clear about consequences. But if the consequences are very severe, they are of that they're in the public interest, then there is absolutely a rationale for sharing information when the person hasn't given their consent. I'm more than happy for my panel member colleagues to wave at me if they want to disagree.
No, I agree, Sarah, but I was just going to say, obviously there's a lot about information sharing in the Mental Capacity Act Code of Practice, where you're sharing information in the person's best interest. But also in these kinds of situations, it's often not so much about giving information as asking for it. You know, you're not sharing information about the person with someone else. You're saying to them, tell me what it's like, you know, tell me what you think, tell me what you know about, you know, so it's a sort of slightly nuanced version of, you know, being aware of protecting their dignity and privacy and so on, but asking for that information, and where they lack capacity, the information sharing, we can share in the best interest.
Thank you, Lorraine. I think it's back to me, so I'm just going to draw us to a close. Thank you for your questions. Thank you for signing into the webinar. I'm very sorry about the technical issues people have had, but hopefully you'll be able to catch the recording and we'll find it of just as much value. Thank you to my fellow presenters. But last and definitely not least, thank you to Jivani, who has been our producer for the webinar, and she's managed remarkably well. Thank you to Kellyanne Perry, who's been supporting us in putting this together from Warsaw. It really has been a team effort. And I must thank Ben Leach, who's not on the call, who's on holiday this week, how dare he, but he actually played a big part in helping to get this organised as well. So have a safe trip home, everybody, and do share this presentation with your colleagues and take away some of those key messages and challenges that we've put back to you. Reflect on the people that you've worked with, reflect on your practice, think about Victoria's key questions for your organisation. Take care, everybody, and stay safe. And don't forget, there's a feedback form for you to complete at the top of the Q&A. Please do that for us. It will help inform future sessions. Thank you very much, everybody. Bye-bye.